Very good. Well, welcome everyone. Thank you for being here. Today we are starting the webinar on top 10 legal mistakes that business owners can do. And as the title says here, that can do or destroy a business. So thank you again. We have Law for Small Business, our partner with MBDA that will be doing a webinar today. Again, we're at the New Mexico Minority Business Development Agency. We have a series of webinars that you can always go to our website and register. We have this one today. We're going to have the same topic in person in Las Vegas, New Mexico in the coming weeks. We're also going to have one on climate resiliency and preparedness for businesses with all the floods and fires that are happening in our state. And without further ado, I will turn it over to Larry. Again, reminder, please click the globe on the bottom of your screen for English or for Spanish so that you can choose and hear the webinar. Thank you.
Thank you, Gabby. And it's a pleasure to be giving this presentation on behalf of my law firm, Law for Small Business. I do want to tell you that there is going to be both English and Spanish presented to this. And so please click the globe at the bottom and you want to select interpretation. And under that, select the appropriate language that you want. I have a Mac and I do not have a globe. I have 3 dots that are for more. And if you click that, you'll get a menu of stuff. Look under interpretation, and then you can select the language that you want if you don't see a globe. There should be an icon that might allow you that, depending on the browser or version of the software you have. If you have any questions or you can't hear properly, just put it in the chat. We're monitoring that, and we'll do our best to make sure that you can hear us and move along. So with that, I'm going to talk about the top 10 legal mistakes that I see businesses do over and over and over and over again. I am an attorney. I've been an attorney for 30 years. And what I've done is I've kind of, I can't say I get exhausted dealing with the same problem over and over again. But what it's clear to me is there are a lot of really important legal concepts that they just don't teach in high school or in college. Even, those with MBAs don't know some of these real standard practical things. And what I want to do is I'm gonna go pretty fast, and I apologize, but please contact the Minority Business Development Agency, and they can give you a copy of this presentation. And so you don't bother taking notes. We're also going to have the video of it available for you, so you can refer back to it. But if you're going to be in business, if you're going to be an entrepreneur, own your own business, or even be a leader in business, it's important to know these concepts because it's going to keep you out of trouble, legal trouble at least. And with no further ado, let's jump into it. First, I'm going to go I'm an old fart. And the reason I say that is I used to love David Letterman, and he had these top 10 lists, and he'd start with number 10 and then go up to number 1. And I'm going to do the same thing here. So the most important thing is going to be on the number 1 thing, but all of these are going to be important. So number 10 in the list is not obtaining professional help or ignoring the professionals. I strongly recommend that you're on a first name basis with a CPA, banker, and attorney. If you have tax issues, you talk to the CPA. If you have cash flow issues, money issues, the banker. And then dealing with third parties, whether it's employees or partners or customers or the government, IRS, that's an attorney. There's some overlap with all of these folks. But in general, stick to that high-level thing that I mentioned earlier. Third parties, lawyers, tax issues, dealing with. I'm going to go into more detail in a minute. On the internet, you need to be very careful because there's a lot of what I call ticking time bombs. There's a lot of people with opinions out there, and I don't know. My father used to say opinions are like, and then he'd use a a dirty word, elbow would work, but there's a lot of opinions out there, but a lot of them aren't correct. And so whether it's Reddit or even AI, you're going to get a false sense of accomplishment. It's going to sound good. It's going to sound like somebody knows what they're talking about. But even if they do know what they're talking about, does it apply to your fact pattern? Does it apply to your jurisdiction? You don't know that for sure. And that's why you really need to be on a first name basis with a lawyer to pick their brain. Hey, I read something. Here's what I want to do. Is it the right thing to do? An attorney is going to be able to help you with that. What you want to do is find an attorney who understands your particular business and your industry, who's going to be respectful to you, but not sugarcoat things. They listen. They're going to be accessible. It doesn't take them a month to call you back. Most business owners, I find if I can't contact them back within 24 hours, they've moved on from the problem, which is not a great thing. We lawyers need to be available and answer questions right away. You should really talk to the attorney when you're starting out, when you're interacting with a third party, and finally, when you're in a dispute. I have business owners and partners and clients who will resolve their own dispute. And then guess what? They didn't put it on a document or a settlement agreement. And then the dispute comes back, even though they may have thought they took care of it or paid the customer, or they did whatever was demanded of them, they still deal with a lawsuit. So we lawyers can help you avoid stuff like that. For CPAs, you want to be aware of information on the internet regarding gross receipts tax. It's somewhat unique in the United States, and you do not want to get behind on tax payments. It can follow you to other jobs. It can follow you to other companies that you might create. And a bookkeeper is not a CPA. I'm not knocking bookkeepers, but CPAs are going to know what the legal issues are. And if you can get a written opinion from a CPA, that can help you avoid potential criminal sanctions. It could help you avoid penalties. It won't help you avoid interest, but maybe penalties because you were trying to do the right job in consulting a knowledge person. I want you to be aware of the lemmings, and that goes like this. This is what other people do, so therefore you should do it. That's the lemming theory. They jumped off a cliff, so you should jump off a cliff. That is not a good way to make decisions, unfortunately. You want to seek a CPA, the same thing with a lawyer who understands your business and industry, will guide you, listen to you, is accessible. CPAs are going to be really important to when you're first starting out and creating a chart of accounts to keep track of your proper expenses and revenues and the categories for those, because they could be taxed differently. When you're trying to figure out how to record, to keep track of and pay any tax, especially gross receipts tax. We get a lot of clients that get in trouble with that. And then when you're trying to determine what it is not a deductible or exempt, CPA is going to help you with that. We have bankers. I want to warn you, bankers are not finance companies. Finance companies are not bankers. Finance companies you can find all over the internet, and you're going to find all kinds of money, and it's going to seem like it's easy to get. The problem is there's going to be huge upfront fees and hidden costs. There may be outrageous contracts that are hard to get out of. And if you get behind in a payment, heaven forbid, it's rare that a business leader is able to get caught up again. So avoid finance companies. I'm talking about bankers, local bankers in the community. And again, same thing. Find bankers that understand your business and your industry, listens to you, and is accessible. You want to talk to a banker and find a banker when you don't need money. That's the best time to get a line of credit. And maybe you don't need it for a year or two. That's great. But then someday there's going to be a really important or big client or customer that is going to slow pay you or not pay you, and you'll have a line of credit to keep your business afloat and moving. Also, it's really helpful to be able to call somebody and say, hey, I got this weird check. I got this weird deal. Is this fraud? It will help you avoid fraudulent transfers and suspicious payments. Also, bankers are great, as well as CPAs and lawyers, to make introductions to other partners and other opportunities for you. Number 9, doing business as a sole proprietorship or partnership. Do not do business as an individual. You want to form an entity or corporate entity around your business. It provides 4 primary benefits. liability protection, survivability, which means it will survive you if something happens to you, provides additional tax benefits, and then finally, flexibility, meaning it gives you opportunities to partner with different people or do different things, maybe separate from yourself or separate from other business opportunities. It can create silos for you for your different businesses or entrepreneurial ventures. If you don't have an entity, you can be personally liable for all debts and obligations of the company. And you can be liable for your partner's screw-ups, even if you tell your partner not to do something. And why is that? Because in New Mexico, there's a thing called a de facto partnership. Just by working with somebody else can create in furtherance of a business, can create a partnership, even if you don't sign anything, even if you don't have a contract. And so that means if this partner that you thought you're going to do a little bit of research and look into a business or maybe help you, you could have a big problem on your hands. So don't let that happen to you. The popular entity types are an LLC, and we do probably 90% of the businesses we create are LLCs. The reason is they're inexpensive to set up, they're inexpensive to maintain, they have flexible tax options, and the operating agreement serves as a partnership agreement. It's pretty simple, it's pretty inexpensive, and it's very effective. Corporations are also very popular. It's a more formal structure. It's more expensive than an LLC, and it's a pain in the butt to take down when, and if and when you want to close that business someday. C corporations can go public. Venture capitalists tend to prefer corporations over LLCs, but I'm seeing that less now. I think venture capitalists and angel funders and so on are more used to LLCs nowadays. But I do want to tell you, when you're talking to a tax expert, if a tax expert says something like, you need to be an S Corp, verify they're talking about tax status versus entity type, because a LLC can be taxed just like a corporation. An LLC can be taxed as an S Corp or a C Corp. LLCs also have two other types of tax treatments, by the way, disregarded and partnership. So before you go and talk to a tax person, they say, get a corp, C Corp or S Corp. Try to avoid forming a corporation if you can. Verify that their recommendation is based on the tax status, not the entity type. And typically, what's really effective for people is to form an LLC, tax it as a disregarded entity because you're not making a lot of money. You don't want to spend a lot of time and effort dealing with taxes. And then if and when it starts making money, you can change its tax status to something more appropriate that is recommended by your CPA or tax advisor. Number 8, poor business naming choices. I see this a lot. People like to be very descriptive with their business. You have a hamburger stand. People want to name it Hamburger Stand or Albuquerque Hamburger Stand. What you need to do is avoid confusingly similar names with other businesses or other trademark holders. You can get yourself in trouble with that. And this should go without saying. You don't want to form a company or a name that's difficult to spell or generates millions of hits on Google. How do they find your business versus one of those other millions of hits? So you want to do something that's unique. You want to avoid descriptive terms, like I mentioned before, Albuquerque Hamburger Stand for an Albuquerque Hamburger Stand. When I say the word Amazon or Apple, those are not descriptive terms, yet they connotate a service, don't they? That is a very strong brand. Those are not descriptive terms, and therefore they are very valuable and helpful when people are trying to do business with those businesses. What I call naming nirvana is the following: unique, easy to spell, suggestive, clever. The .com is available. I was involved with a company called Fat Cow Web Hosting. We had the domain name fatcow.com. We had a trademark for Fat Cow. People can spell Fat Cow. There wasn't a ton of Fat Cow on the internet if you search for it. And so that ultimately created a very valuable business where we were able to sell it for over double what a typical business like that would go for, all because of the name. So a good name, if you meet the naming nirvana, and that's hard to do, is really going to add value for you. Now, the litmus test you should be thinking about when you name a business is, can you trademark it? And you need to look at the legal test as likelihood of confusion, not a direct hit. So when you see these trademark services on the internet, they say, well, we'll do a direct hit search for you. Who cares? That's worthless. You need a likelihood of confusion search, which is much more difficult to do because likelihood of confusion looks at similarity, not same, in look, sound, or meaning of the mark. It also must be used as a source identifier, meaning it's just not a name out in the ether. If I say Nike, you expect it to be attached to the label in the tag and the packaging of shoes or athletic wear. That's what a source identifier is. It's tied inextricably to the product or service that you're selling. Cannot be descriptive. And there's a million other rules, unfortunately. And so talking to a trademark lawyer might be beneficial depending on exactly what you're doing. But let me give you an example of one that's just nuts. I mentioned Albuquerque hamburger stand. That you could not get a trademark for because it's descriptive in many ways. One is it's geographically descriptive. If you are an Albuquerque hamburger stand in Albuquerque, you're geographically descriptive, and so you can't trademark that. But let's say you had Albuquerque hamburger stand in Santa Fe. Could you trademark that? No, because now that's called geographically misdescriptive. Now, Albuquerque really isn't known for hamburgers that well, so but let's use Cuban cigars. If you wanted to create Joe's Cuban cigars, that would be geographically misdescriptive if you're not located in Cuba. If you're located in Cuba, well, then you're geographically descriptive. So either way, you're in trouble. But this is the test you need to think about in the back of your mind. You have generic names on the left, and you move to descriptive, suggestive, and then arbitrary. Arbitrary names, and I mentioned a couple earlier, right? Like Apple for computers, Amazon for an e-commerce company. Those are considered very strong names, very easy to spell and say, and that's what you want to do, and avoid descriptive terms for your business. I know you want to because people don't know what your business is, but you can put that in the tagline. You put that in the ad copy, maybe your logo, so maybe your name is Fart Knocker. What is it? Well, you have a picture of a man with a saw, maybe suggest construction, be creative. Public loves that. So number 7, no knowledge of the work for hire doctrine or copyright law. The general rule is authors own the copyrights of the works they create, unless they're a W-2 employee. So I need to explain this a little bit. And why do you care? Well, at the end of the day, you have a business, and let's say it's a dog grooming business. Let's say you make cakes. You're a caterer. You may need help doing logos or ad copy or work product. Maybe you need somebody to write an app for you or some software. All of that, or a jingle, a video, maybe you're in production of some sort. All of that stuff is work product that's copyrightable. And the people you hire, if they're contractors, if they're vendors, are going to own those copyrights. And so we've seen instances where a business will hire a vendor to do a e-commerce website for them. And then they'll spend hundreds of thousands of dollars on that e-commerce website. And then that vendor will go around and turn around and sell that exact same website and the technology to the competition. Is that legal? The answer is probably, if you haven't thought about these rules I'm going to tell you about. So that vendor owns the copyrights unless they're an employee. What is a copyright? A copyright basically says, and this is automatic in law, that the copyright holder owns the exclusive right to publicly display, sell, transfer, copy, and create derivative works of that work product. Again, the exception is employees. So if you have a company and you're paying real money to somebody to take photos, make sure that you own the copyright, not the vendor. And you do that through what's called a contract for a work made for hire contract. And I'll explain that in a minute. But there's another problem associated with this. If you pay somebody to do something and they go and steal that something from somebody else, you are still liable, even if somebody else did the stealing. So let me give you a real world example. You hire your niece to help you do your website. That's great. I encourage getting family members to get involved in your business, but the niece doesn't know about this. So she goes to Google and searches for images. And guess what? She finds a really beautiful image of the Sandia Mountains in the backdrop at dawn, the early light coming up with all the balloons out there, really beautiful. And she puts that on your website. Well, guess what? You don't own the copyright to that. That's on the internet. That's somebody else owns the copyright to that. And it's specifically some photographer who specifically put this picture out on the internet so that people will steal it. And he has some sort of New York law firm. That's their only job, is going after and suing businesses that use this image without obtaining permission. So copyrights goes both ways. One is when you're asking for work product for your business, making sure you own it. And the other thing is when somebody's delivering stuff, and instead of creating a unique thing, like a unique photo or a unique drawing or a song, they go and steal somebody else's and bring it to you. You can get in trouble in either way. And so you need to be really careful about this. So Statue of David, who owns the copyright? Well, this is a long time ago, but let's pretend this is a new thing. And the Medici family hires Michelangelo. Who owns the copyright? The answer is Michelangelo owns the copyright, and the Medici family owns this particular statue, which means the Medici family, without a contract, can only put this in their private collection somewhere. They can't even display it publicly in the city center unless they have permission from the copyright holder, who is Michelangelo. What about taking a photo? Who owns the photo of the Statue of David? The answer is Michelangelo. So anybody else taking a photo is then violating Michelangelo's copyrights unless they get Michelangelo's permission to do this. So you can get yourself into trouble with photos, websites, software, logos, articles, videos, music. The only way to fix this is a contract that assigns all rights back to you with what's called a work made for hire clause. You want to make sure, another thing is if you hire a marketing person to maybe do social media for you, make sure those accounts, those social media accounts, are in your name. They're your accounts and they're being paid for by you with your credit card. So it's a little frustrating because maybe you don't understand technology very well. I'm a tech guru. I've been doing it for a long time, and I find it exhausting to have to go and create a new Instagram, TikTok. So I got to go and create an account, figure out how to do it, set up the financial stuff, and then let my marketing people access that account. That's what you need to do. Otherwise, you open up the possibility of them souring the relationship with you or moving on or trying to charge you more money, and then they don't want to give back the account credentials. All that effort you put into building your marketing and brand in social media or other accounts then becomes lost or frustrated because of that. Don't let that happen to you. You also want to make sure there's an indemnity clause for infringement actions. Can your niece indemnify you? Probably not. So maybe your niece isn't a great option for building your website. Can a professional vendor like Sunny 505 indemnify you for infringement? Yes. So there is some benefit by hiring a vendor. It costs more, but you're going to get original work product. And then if they screw up, they have the ability to fix things and make you whole. So that's where I suggest hire reputable people. And I'm not trying to knock people in other countries. However, if you hire somebody from Ukraine, India, Taiwan, China, we have a very difficult time holding people in other countries accountable. So it's better to hire somebody local or from a country that you know you can hire lawyers and hold people accountable for. And when you're talking about intellectual property, software, things that are expensive or maybe valuable for your business, this is really important. Number 6, no contracts with third-party interactions. So I'm going to give you a little bit of a lesson here about contract law and how important contracts are. They're critical to maintain accountability and establish responsibility for both you as well as the other party. Ensure payment so you get paid on time and you don't have to hire a lawyer, or if you do, you get reimbursed for hiring the darn lawyer just so you can get paid. They permit termination when needed. If you don't have that written down, can you terminate services from somebody? Maybe, maybe not. Why have that fight? Write it down. And then, and vice versa. If you're expecting services, you know, you want a term around it and you got to think about it. A super long term might be a problem when you're hiring somebody if they don't deliver. You want to be able to terminate. Vice versa. If you're providing services, the longer term you can get, probably the better for your business. You also want to limit or establish warranties and indemnities and liabilities. I had a contract, a garage cement resurfacer client, and he resurfaced a big floor of a custom home in Santa Fe. And unfortunately, that custom home's foundation wasn't thick enough and it was cracking. And all my client did was do a surface. This surface isn't going to hold the cement, foundation together. So it kept cracking. And the client kept ordering our client back to redo the surface. They went out 7 times before they finally called me and said, how often do we have to do this? And the answer, believe it or not, was a little complicated because they did not have a warranty clause in their contract. So now the question becomes, well, what is reasonable? What is standard? And it's debatable. And we lawyers love a good debate. Do you know why that is? Because we make money on our time. And so if we get to fight and argue about things, we are making money. So don't feed the lawyers by having ambiguity in your contracts. The less there is to fight about, the less legal fees there are to spend in dealing with disputes. I want you to remember that. When you hear a lawyer say that's hard, that's going to be a lot of arguments, think expensive. And vice versa. When it's easy or we're not arguing about things, that's not very expensive. That's the category, the place you want to be in. And similarly to what I'm talking about there is it can control dispute resolution. How do you fight when somebody has a complaint? How does that work? Do they sue you right away? Do they got to go to mediation or arbitration? It can save you a lot of money depending on how you handle that. It helps you avoid expensive lawsuits, as I mentioned. It can also help you in certain areas around confidentiality, non-compete, non-solicitation, and trade secrets. If this is important to you, you don't want people hiring your people away. Now, non-compete is complicated. The FTC has passed some rules around that. So you want to talk to a lawyer about what is or isn't permissible on non-compete. There's some important issues to know about. A lot of people don't know. One is, if you're in the business, New Mexico, they really try to make it difficult. I really feel this. They try to make things difficult for businesses. And there's a consumer protection law called the Unfair Trade Practices Act. Basically, it's not for businesses, it's for consumers. It's for businesses hiring other businesses. So a business can be a consumer against another business. But if you provide products or services and they can argue there was some sort of malfeasance on your part, some sort of error, mistake, misstatement of fact, fraudulent statement, they can argue unfair trade practices. And if they can prove it and win, they can get 3 times their damages plus attorney's fees. So suppose you're a website developer and then, you deliver a website that is according to spec, but then they argue you said this website was going to be all I needed to generate all the business I wanted, and I'm not generating any business. And then you say, well, it requires you to market. And they say, you didn't tell me that. Now they can do a UTPA claim. They can argue that you misled them, but for the misleading statements about how great a website is, they wouldn't have gone forward. And now you're fighting off 3 times their damages. What is their damage? The fee they paid you. So you're having to defend that, paying lawyer money, and then maybe paying their legal fees if they win. You don't want to be in that situation. And so what you want in your contract is legal fees go to the prevailing party. So if somebody's going to go after you for this, they better win, and they better, really believe what they believe. Otherwise, they'll end up paying your attorney's fees. And that helps keep people from using the legal system against you. Another thing people don't know about is a merger clause and parole evidence rule. Basically, you can have an oral contract. Yes, you can. But if you have a written contract, it's going to override anything that was orally said. So if somebody hands you a contract, and I'm going to go over this in a few minutes, but if somebody hands you a contract and then proceeds to tell you what's on the contract, the words out of their mouth are absolutely meaningless. I've been involved in litigation where the contract was actually the opposite of what was verbally said. And that's, so what? There, you look at what's in the document because of these contractual rules. So you need to adopt standard contracts for your business. And a lot of businesses, it depends on your business, but if you have a proposal or a work order or an estimate or something like that, what you want to do is sell to the decision maker. So don't have legal language in the sales stuff. Proposal should just be about your products, your services, time, delivery, the sexy stuff that gets them to say yes about your business. And then once they say yes, then present the contract. And so what you're doing is taking the contract away from the decision makers and putting it into the people that are just trying to finish the deal because they already decided to do it. If you give a contract to a decision maker, that might slow down the decision. A lot of people don't like legal mumbo jumbo, so don't give it to a decision maker. Consider intake forms when appropriate. That's like an attractive first page with basic information, and then the back side is, in the gray, smaller print, or maybe there's subsequent pages that people don't read. You want a standard employment in a contractor agreement for everybody you hire. And if you do it correctly, you're going to have one template for everybody. And then you change either the proposal or the work order or whatever for subsequent jobs. And you attach them as an exhibit to your template agreement, if possible. So number 5, disputes with partners or no or poor formation documents. I want you to think about the following list here. All of these things, these are all issues that I've had to deal with as an attorney. Terrible behavior, physical altercations, people that embarrass the company, get arrested, leave, steal things, or just want their money back or something like that. The only way to protect you is to have appropriate partnership documents in place. If you have an LLC, it's an operating agreement. If it's a corporation, it's bylaws, and then you have other optional agreements such as a buy-sell agreement, restriction agreement, or purchase agreement. I can't tell you how many business owners I talk to, and they're like, "Oh, I want to give ownership to my employees," and I say, "That's great. What happens when you fire them?" And then there's this awkward pause, and they're like, "I don't know. I don't plan on firing." And I'm like, "That's great, but what happens if you do want to fire them? Do you claw back the ownership? Do you do business with family members if they die?" You need to think about those issues and then put them on a piece of paper. We never, ever want to fight about that. Why? Because you make the lawyers rich and you take money away from your business. You don't want to do that. So the other thing you need to know about is the law. There's very little statutes, regulations that control bad behavior. It's very difficult to remove a partner and enforce your rights. The default statute is very general, very high level. It doesn't go into detail. It doesn't say partners can't steal. Now, you would think, well, that's called embezzlement, right? Partners can't embezzle. True, partners can't embezzle. However, partners are entitled to distributions. Partners are entitled to liquidate and sell assets and move stuff around. So how do you show that something is embezzlement versus a distribution? It becomes murky, and you can argue it. And remember what I said about arguing, right? Costly, difficult, may not win. So the other thing I want to tell you is do not just walk away if things aren't working out with your partner. It's very important to negotiate a settlement agreement on leaving. Number 4, too quick to sign contracts without reading and negotiating. So this is very similar to the contract discussion that I had a little bit ago, but there's a few other things I want you to think about when a contract is in front of your face, when you're looking to sign. I want you to think about the proper legal names of the parties and all the promises mentioned. Are they in detail? Now, with the parties, who's the other party? Is it Acme? Who the heck is Acme? So what is it they're doing for you? Are they taking a lot of inventory? Are you putting them in a position of trust? Is there a lot of money involved? Maybe you need not to do business with just Acme, but you need to know who the owners are. You need to think through, if something happens, how do you hold them accountable? And if it's just this Acme, where are they even located? Make sure that we can identify who the responsible party is so we can go after them. And then promises, you want to make sure that it's a promise that you can adhere to, that you can fulfill, or that you can hold them accountable to. So promises need to be specific, measurable, time-bound, not marketing. What the heck is marketing? Is it, 2 AdWords in a month? Is it $20,000 worth of AdWords? Be specific, or you can get yourself in trouble. And ask yourself, what can go wrong? What are the edge cases? Do we have those addressed in the contract? Are the dates and dollar amounts correct? Are you making too many promises? What happens if you can't fulfill those promises? Are you in control of the promises you're making, or are you relying on other parties, other people? And if so, maybe you need some qualifications. We will do our best to provide the service as long as there isn't a pandemic, as long as our suppliers are able to supply, as long as your doors are open, whatever is appropriate for your business. Is the contract fair and balanced, by the way? One-sided contracts are going to get you into trouble. And interestingly enough, we're going to talk about the number one problem involves one-sided contracts for a specific thing. I'll talk about in just a minute. Is this a mission critical thing? If so, what are the long-term implications? If you're totally reliant on this one vendor, and if they just cancel the contract, your business is in trouble. Maybe you need some warning before they cancel, or notice, or some time frame between when they issue notice to cancel or terminate and when they finally terminate. Think through those issues and make sure you protect your business. Is there an evergreen clause or a deadline to invoke an option? In New Mexico, if you're 1 day late in issuing a notice to renew an option, you're dead. So imagine, for instance, a land lease where you're leasing land for 99 years and you have 2 options to renew. If you are off by a day at the notice requirement, you lose your ability to renew that option. Don't let that happen to you. What happened? I mentioned pandemics earlier. What happens if something like that happens? Do you have the right to slow down or terminate or suspend services for a period of time? Think through those edge cases. So this is a little edgy, and I apologize, but it's important. And this is why I'm using harsh language. This should really upset you if anybody does the following: hands you a contract and then tries to explain it to you than you just reading it. Remember what I said, the words out of their mouths is irrelevant. to what's in the contract. So just put your hand up and politely say, please, I can't read this while you're talking, and then read it. And if they act impatient, then push the contract back and say, well, if it's clearly a problem for you right now, I'm happy to review it and sign it later. You know, don't let people rush you and mess with you on that. If they say, don't worry, I know it's not in the contract, but here's what we do. If it's not in the contract, you can't hold them accountable to it. So tell them to put it in the contract or you're going somewhere else. Do not ever let somebody tell that to you. And I mentioned pressures you to sign right away. Do not fall for the pressure. It's a common scheme where they'll say, oh, we don't have time for this. We got other buyers. You know, you need to, jump in, or we're going to get this to somebody else. Then just be like, then give it to somebody else. Do not let yourself get pressured. The other thing I'm going to warn you about is people that represent both parties to a transaction, like a broker. Now, there are really good brokers in town. So I'm not trying to knock all brokers, but brokers are inherently conflicted because all they want is to get the deal done. And the deal may not be right for you, or there may be important aspects of a negotiation that you may not know about because it's not part of the deal, and you just go forward not knowing that you had some other options. So be very wary when you're dealing with people that are representing both you and the other side. You could be missing really important things, and I want you to approach that very carefully. You should also get really upset with any contract that awards attorney's fees to the other side, but not you in a dispute. The best language would be mutual, and the attorney's fees goes to the prevailing party, or contains a lot of penalties for you, but not for them. It needs to be balanced, fair and balanced. Also, be very, very careful for contracts that have a lot of specifics on you paying, but not a lot of specifics on what the other party is doing. Remember my example of marketing. What does marketing mean? Oh, you got to pay $25,000 a month. That's very specific, and it's got to be done on this day, and you're going to have late penalties, blah, blah, blah. You better pay your $25,000. In return, we're going to do marketing. What does marketing mean? Be specific. Make sure you're getting your $25,000, and you should be able to cancel the contract or stop paying if they don't meet some thresholds, some specifics. Be very angry if somebody gives you a contract like that because they're trying to pull the wool over your eyes. Number 3, doing things illegally or incorrectly. You need to be aware of the state is really not looking out for you. And there's some really good people with the Albuquerque Economic Development Group, other economic development groups. They're trying to make business work, and they're fighting the same machinery that you are. But at the PRC, at the Secretary of State, at the RLD, Regulations and Licensing Division, all of these entities, they don't seem to tax and rev. They don't care about your business, and they don't necessarily verify what you tell them. So the Secretary of State isn't going to tell you whether your business name infringes on somebody else's trademark, for example. Don't take what the state tells you as, okay, I can do this. They don't do that. They don't analyze things. Just because somebody's name is listed with a company, it doesn't mean they own the company. It doesn't mean you own the company. Just because you get a business license from the city of Albuquerque, or you get your LLC from the state, doesn't mean you can serve food, or you can practice law, or practice medicine, or even do contracting services. That's another agency. So you got to be really careful, because you may think you're doing something correctly because somebody said, sure, put a stamp on your company or something like that, but that doesn't necessarily mean you're good to go given what it is you want to do. You really need to talk to somebody to verify that. So you got to be careful of the mission accomplished, job well done. What you get is this like ticking time bomb where you got your company, you think you're doing things correctly, and then guess what? You forgot to get the appropriate insurance. And now you got this time bomb waiting. You start hiring people, somebody gets hurt, and now all of a sudden, boom, you don't have the right insurance and you're in trouble because you didn't do all the things you needed to do. I mentioned lemmings earlier. Beware of the lemmings. Do not do things just because other people are doing them. Talk to the experts. Make sure you're doing things the way you're supposed to, because guess what? There's a lot of lemmings out there that aren't doing things correctly. And remember, if a lemming jumps over the edge of a cliff, should you do that just because other people did that? Of course not. Don't let that be you. Beware of what's called negligence per se. What this means is if you or your business or your agent, that is an employee or a contractor or a partner, even if you tell them not to do something, they still do it, you're still in trouble. So if somebody commits an illegal act, like speeding, and somebody gets hurt, that's negligence per se. Digging in the ground and digging up a gas line and people get hurt, or digging in the ground and breaking a fiber optic cable, that's negligence per se. If you don't have a permit and you violated the law. So you maybe you serve food, but you don't have the right permit for that. Negligence per se. You can get yourself, your company, and others into a lot of trouble if you're not careful. So the other thing I want to bring up, and you should know this, right? But poor decisions and bad behavior will eventually catch up to you. And I'm not saying you are making poor decisions or have bad behaviors, but maybe your partner or maybe an employee, that's going to catch up to you. Don't put up with it. Your business is your number one most important, valuable asset. Don't let somebody jeopardize it like that. There are a surprising number of things that can actually create jail time for you, actually going to jail. So providing services without a license, for instance, if you try to act as a lawyer and you don't have a legal license, if you should know this, right? But you'd be surprised. More benign things could create problems. For instance, serving people food. If you don't have the right license for that, and you go through the right inspections and protocols, you could get in trouble if you make other people sick. So be careful about that. I mentioned illegal acts. If somebody gets hurt and you're either unlicensed or it's not permitted or it's illegal, and an agent like a contractor or employee gets somebody hurt, you can get in a lot of trouble for that. And then the other thing I'm warning you about is securities, improper franchises. I can't tell you how many businesses are like, oh yeah, I'm going to franchise this out. And you got to be really careful. You got to hire a special lawyer for that because every state's laws are different. And if you don't do it right, you could have serious jail time, especially California, Illinois, New York. They have really, strict laws on the books for something like that. So be careful. Number two, improper classification of contractors. This is over and over and over again. Businesses are having trouble with this, and I don't want it to be your business. The general rule is that if an individual is an independent contractor, if the payer, that's you, has the right to control or direct the results of the work, not what will be done or how it will be done. So let's give you an example. Let's say you hire a painter and you want to control the color. You want to control where it goes, right? That all makes sense. But if you're going to be telling the painter what brushes to use, how to actually paint and put their stuff down, then it starts looking more like an employee versus a contractor. In New Mexico, in our wonderful wisdom, we think we're better than the IRS. And so we have another requirement, and that is if the individual is doing work in furtherance of your business, they're an employee. So like me, Larry the lawyer, I can hire another lawyer from another law firm, and New Mexico law says they're an employee because they're practicing law and doing work in furtherance of my law practice, even though they have another company. So it's really, really annoying, unfortunately. And I see people like, for instance, dealing with like daycare services, salons, beauticians, nail salons, stuff like that, massage parlors, service-based industries get themselves into a lot of trouble when they hire contractors Therapists, actually, I see a lot of problems with that as well. So you need to look at these factors, these common law factors, the behavior. Does the company control that or have the right to do it, or does the worker control it? Financial, who's collecting the money? Is it you and your business collecting the money and then paying the contractor, or is the contractor collecting the money? Are you paying them and it has nothing to do with your business? That sort of implies a contractor position versus an employee position. And the type of relationship, is there benefits, there are other aspects of the relationship that kind of feel or look like employment. The duration as well could be a potential problem. You need to look at those issues to determine whether you have an employee versus a contractor. And you need to be very careful because you could owe back pay and withholding taxes, penalties, interest for all former employees and contractors if you get this wrong. I've seen the IRS impute unpaid salary. I've just seen them, say you've been underpaying them below what the minimum wage is. And you're like, that's ridiculous. They just come in. I've had a client, I'm not exaggerating. They had some contractors come in at 8 to do like one job for an hour. Then they went to their other job and then they'd come back at like 5 or 6 and do another hour or two worth of work. It was just a small part-time thing, but my client wasn't having them clock in and out. It was just on an honor system. And so then one employee made a complaint. The IRS and Workforce Solutions came in and looked and did an investigation and said, well, you've indicated they come in the morning and they're here in the evening. So we're going to assume they were here the whole day. And based on what we see you've paid them, you've significantly underpaid them. And so now you owe them this ridiculous amount of money. And then guess what? That employee then goes and tells his or her friends that what they were able to pull over on you. And so then the other former ex-workers of your organization now start making complaints and come after you. And then they think, what the heck? You aren't keeping records. You're on the honor system. So even people that were not employed by you are now making complaints. And you're having to defend and disprove the negative, which is really hard. That person X was never an employee of your company. Don't get yourself in that situation. So think about how to defeat people trying to defraud your business like that. And if you want to get it right, talk to a business lawyer or CPA. There's a form SS8 with the IRS where they will actually give you a definitive opinion letter. But that doesn't always work with the state, as I mentioned earlier. So it's better to talk to a professional about this. Finally, we're down to number 1 and we have 4 minutes left. Leases and inexperienced business owners. You need to be aware of there's no laws protecting business owners from bad landlords. There is no such thing as a slumlord when we're talking about commercial rental property. The contract is it. There's no law that says you need to have heat or cooling. The landlord has an automatic lien on your property. There is no law that says your neighbors have to be quiet or that your business should be free from noise or odors from the other businesses and stuff like that. It is only what is in the contract, the lease, that applies. I mentioned heating or cooling a bit ago. You need to make sure you avoid the following with your lease, that when landlord needs to approve something, you want to hang a sign somewhere, you want to change your premises, make sure the approval is not unreasonably delayed or withheld. You want to avoid ambiguous language around payment of funds. You want to avoid long terms, especially if you're inexperienced or this is a brand new business for you. Not because you're not a great person or a great business leader, but it's because the SBA says over 80% of businesses are going to fail within the first 3 years of doing business. So just the odds say there's an 80% chance your business is going to go out of business within 3 years. And heaven forbid, you don't want to have a lease that extends past the time of you going out of business. So it's better to pay a little more money for a shorter term than try and save a little bit of money on a longer term. And the landlord's not responsible for damage that can occur on your property. So make sure that they are responsible for damage. I've seen instances where the lease is covering the roof and the roof leaks. So the landlord's responsible for the roof, but the roof leaks and the landlord's not responsible for any water damage. No, that can destroy, tens of thousands of dollars of your inventory. The landlord needs to be responsible for it, and the landlord needs to make sure there's no leaks on the roof. Avoid expensive penalties for late rent payments, use of force, never ever agree or allow to that. Or don't allow the landlord to move you without compensating and notice. That could be detrimental to your business. Get a lawyer to review the lease and avoid landlord getting attorney's fees. Remember what I said earlier, attorney's fees should go to the prevailing party. You want them to mention specific landlord duties as well as remedies. And if the landlord charges CAM, you should be able to audit that and have a dispute resolution process if they're charging you too much. They're almost always one-sided. And you want to check the force majeure clause. What does it say about acts of God? What happens if you can't let people into your business? Can you forbear the lease payments for a little while? There's a doctrine of impossibility, by the way, but it only applies when there's a big event of some sort and that is a legal issue that has no fault on your own. And that's a very hard standard to look at, and I don't have a lot of time to talk about it, but it's only in very rare circumstances that you can apply something like that. Typically, you don't have the ability to forbear performance, especially payment of the lease, without negotiating and making sure it's in the lease. And if you have trouble paying your lease or meeting the terms of your lease, trying to negotiating with the landlord first before abandoning the lease. The absolute worst thing you can do is abandon things because you pretty much give everything to the landlord to then do what he or she wants to do, including seizing all your property and then going after you individually for the money for the remainder of the lease, even if they end up finding another renter for the lease. Don't let that be you. Quick lessons, force majeure clause. Look at that, make sure it fits your business. Beware of a non-essential designation. Try to analyze is your business is an essential business or not. If this is a COVID situation, do you need other space changes? Think through those issues and make sure that they're negotiated in your lease. And I went 1 minute over. I do appreciate everybody's time and joining us, but these are the top 10. Don't let them affect your business.
Thank you, Larry. You really rushed through that to get all the information. So we appreciate it's a lot of content. So again, as a reminder for all the participants, we will email out this presentation. It's recorded, so we will post it on our YouTube channel. I'm getting awesome, thank you very much, comments. If there are any questions, maybe we have a minute and we can ask any questions to Larry directly. I see Robert. So Robert, let me try to allow you to talk. Go ahead. Now you have to unmute yourself, but you should be able to. You can also, go ahead.
Does he have to click English or whatever? Or is that the,
I think he's good. Robert? Oh, maybe he does have to click English on the globe on the bottom, or if you have a Mac, the 3 dots. You can also type it. Robert, you were unmuted for a second. You're muted now. Maybe you have to click English on the bottom. Sorry. We are trying something new, everyone, where we have interpreting in Spanish so that it's recorded in the Spanish language. Robert, I see you clicking muted and unmuted. So, but if you want to try typing it out, you can also do that. But again, while we try that piece, everyone, we're like so grateful for your time, Larry, and sharing all this information. For those in Las Vegas, New Mexico, the same presentation will be there in person. So on August 7th, in a week from now. Robert, I don't know if you still have a question or not, but your hand came down. So feel free to call me and I can connect you with Robert. Okay, your hand is up again.
I hate when tech does that to me. I
I
think I heard him. I did,
thought so too.
but he's on mute again, it looks like.
Mm-hmm. Robert, I'm trying to see if you're, yeah, I'm not sure why. Maybe it's you have to press the English piece. But anyways, give me a call, Robert, and we can make sure to connect you with Larry. Again, also, Larry and his firm are offering 1 hour free consulting services questions about legal. So if any of the business owners here, or if you're watching on the YouTube later, feel free to connect us and we will make sure. Okay, actually, Robert is calling, so I'm going to put him on speaker. Okay, Robert?
Can you hear me now?
Yes.
All right. Thank you, Larry. Good to see you again. I got a question here. That is about contracts. Would you give me maybe a website, maybe some templates for these agreements?
Did you hear the question, Larry?
It's echoing a little bit. I'm not sure why that is.
Yeah.
Maybe I needed to put
That's
maybe
okay. I can repeat the question. I think it's just the feedback. But the question was, you were talking about contracts, and if there's a website or somewhere you can point out for templates for contracts.
Oh, that's a really good question. And it's a hard one to answer, and I apologize. The problem with a contract is it's very specific to the arrangement, and everybody's business is different, and a transaction between two parties can be very different. So getting template contracts is a fraught exercise. As my law firm, we do have, if you search template contracts on the search bar, we do have a page of template contracts. They're very high quality. We use them as a starting point for our clients. And what that means is it's a template. You're going to have to, update it, and we mark where you change things and so on and so forth. But when you go and if you're getting a template from a non-lawyer, it's very difficult to know whether it's a quality document or not, or whether it's going to cover all the issues or not. And we're seeing people like use ChatGPT, for instance, and AI systems to try and generate contracts. And they're horrific. Legally, they look nice and it looks like looks like it's going to protect you, but it turns out they're totally wrong or they're missing some important things. So it's really hard for me to recommend like a place to get really high quality documents, unfortunately. What I will say is probably the best thing to do is to know that any contract has two components, the business issues and the legal issues. So if you can find a document that covers the business issues for your business, then hiring a lawyer to look it over and make sure it's okay for the legal issues will cost less, because that's the big question we lawyers have. Well, tell me about your business. Do you do this? Do you do that? So if you can get all of those answered in a document, then it doesn't cost a heck of a lot to hire a lawyer to look it over. And we do have a service, for instance, $20 per page, minimum 5 pages. So we're going to charge you $100 even if it's 1 page, but we will review it and comment on a document. So that would be my advice for templates is, find something that addresses the business issues and then, find a lawyer to review it and clean it up for the legal stuff would be the best answer to that. And I'm sorry it's such a long-winded answer to what seems like it should be a real simple answer.
Follow within the contract. If there's a list of tenants that you have to.
He's asking If there's like a list of tenants that you can check and make sure that it's included.
List of clauses kind of thing.
Clauses? Yes.
That's the problem. It's, I don't have a list like that, unfortunately. It's going to vary greatly depending on the contract. Like a purchase agreement for real estate is going to be very different from an employment agreement. And that's going to be very different from a contractor agreement. And you think employment agreement versus contractor, it's just an individual in how you classify them, but you can have very different clauses. So unfortunately, I don't have an easy way to provide a checklist for all types of contracts, unfortunately. Another option is we do sell 30-minute attorney consults. Now, you mentioned the free, we do an hour. That's through the MBDA. So we don't offer a free hour consult. We charge for 30 minutes unless it's through the MBDA. We have a special offering there, but you can tell us about the contract, what you're trying to accomplish, and then we can discuss what are the important things you need to be thinking about in negotiating and drafting a contract for whatever deal you have going on.
Thank you so much. Yeah, thank you so much. He's saying thank you. And I'm gonna have to wrap up because I know we're already over 1 hour. So again, thank you, Larry, again, and everyone for attending. Just to reiterate what Larry was sharing, that yes, through the MBDA, I think we have another maybe 8 spots. If there's individuals who like to have a 1 hour legal consulting, we have that available for the next few weeks. So if you're interested, call us right away. If not, of course, Larry and his firm has many services that, you know, you can go on the website, you can learn a little bit more, you can see the templates, you can, you know, have consultation at a cost there. So again, everyone, thank you. We will send out the presentation in the next 24 hours. And thank you. Have a great day.
Thank you, Gabby. I really appreciate everything your organization is doing, and I appreciate the opportunity. Thank you.
Thank you. Okay. Bye-bye.